I'd like to call the work session meeting to order. And I'm sorry I didn't get a chance to come shake your hand before, having only met you previously on Zoom. But I would like to call on Carrie Richter, our special city legal counsel, to introduce our topic today. Thank you so much.
Thank you, Mayor and City Council. My name is Carrie Richter, and I am a land use lawyer with the law firm Bateman Seidel. I think you may work more commonly with my colleague Bill Kabaisman, but Bill and I've worked together for almost 20 years, serving as city attorneys and special land use attorneys for many cities up and down the metro area and the coast and all over Oregon. And one of the things that I have now, it appears, cultivated a little following with is my land use training. So I do these for Cannon Beach, Oregon City. I did it for Planning Commission and your Historic Landmarks Committee, and Heather invited me to come and talk to you. So I am happy to be here. I urge you to ask questions as we go along because I could fill 5 hours doing this. And Claudia has assured me that at 7 o'clock the mics go dead. So this is your chance to ask all the questions you want. Don't ask me about anything that's pending before you. The good news and the bad news is I have no idea what's pending before you. So I can't stop you, and I'll answer any question that you have. So with that, I'd like to just get started. My hope is that everyone takes away something from this, because I know many of you may have lots of land use training and some of you may be brand new to it. So my hope is to sort of hit the sweet spot where everybody learns at least 1 or 2 things. So with that, let's get started, Claudia. And Oregon's land use planning framework, which you all probably know, comes from regulations from 4 different bodies. The first series of regulations that we have to comply with when we're reviewing land use applications are the U.S. Constitution, and the element there that comes up most often is the Takings Clause. And we'll have a chance to talk about the Takings Clause as the final slide of this evening. So we're going to move on quickly. There are a number of laws that become applicable in land use cases. Those are the Fair Housing Act and the Americans with Disabilities Act that we have to comply with when we draft land use regulations to review applications. We have state regulations. We have the Oregon Revised Statutes, and that are the land use chapters that set forth standardized land use procedures that we have to use in quasi-judicial proceedings. Those regulations also set forth special use regulations. Those are the regulations that say what we can and can't do on farmland, and they also say what we can and can't do with housing. Might interest you all to know that for the first time this last year, land use made its second chapter of Oregon Revised Statutes. So statutes are numbered, and when you have enough material, you get a second chapter. So we have 197, and now we have 197A, which makes it incredibly confusing for everybody. Because why is housing in 197A and everything else is in 197? That's the way the legislature did it. So now we have 2 land use chapters. And then there are the land use procedures that are set forth in the local government procedures that say what cities and counties can do. Then we have, from the state level, we have the administrative rules. These are the Oregon Administrative Rules, the OARs, and those are promulgated by the Land Conservation and Development Commission. And they are a state agency that is charged with promulgating the statewide land use goals and implementing them. And so they have adopted administrative rules that tell us how we implement Goal 5, for example, with respect to historic resources. Those rules tell us that we have to inventory our industrial lands under Goal 9. They tell us we have to evaluate our transportation system plan under Goal 12. all of that body of obligations that cities have to go through are set forth in the administrative rules from LCDC. Then there are other agencies that have administrative rules too, like the Oregon Department of Transportation, the Department of State Lands, which governs how wetlands are regulated. So those rules are often implemented by cities in land use reviews. The third body of regulations that we have to deal with is Yamhill County. And Yamhill County, as you know, establishes the urban growth boundary, and then we coordinate in McMinnville with Yamhill County on growth through the expansion of the urban growth boundary. And then what is most applicable and what we use for city land use planning day in, day out are the city regulations. And those are comprised of the comprehensive plan and map, and then Title 17 of the McMinnville Municipal Code, and then the McMinnville zoning map. So the purpose of all of this is to provide a balance, right? The statewide land use goals provide for the protection of certain things, right? We're trying to encourage livability. We're trying to encourage economic development. We're trying to protect resources. We're trying to have efficient and orderly use of land. Those are all statewide land use goals. And then how local governments implement them is sort of up to them. So there's a lovely, I think, balance between what the state says we have to have as local governments, and then how we decide to implement those regulations is sometimes up to us, sometimes not, right? But when the system was created, you want to move forward, Claudia, one slide. When the system was created, Senate Bill 100 was created, the deal that was struck was the state will tell you what the general values are, and then local governments will adopt comprehensive plans and they will implement them. And so that is the system that that Oregon land use is built on. So local governments had to go out and inventory their resources and decide how they wanted to grow, and then they wrote those plans up in transportation plans and sewer plans and comprehensive plans, and this was the long-range plan. And LCDC, we would submit the cities would submit the plans to LCDC, and LCDC would say, yep, it satisfies the statewide land use goals, you are acknowledged, right? And then the statewide land use goals fall away, and we move forward by just applying the code. So every time you get an application before you for a conditional use permit, we don't ask whether it complies with the goals, because McMinnville's zoning code has been acknowledged. But when you amend your zoning code, we have to send it back to the Land Conservation and Development Commission for their acknowledgement. Once it's acknowledged, we're able to move on and just apply the code. So that's the way it was set up, right? We have urban growth boundaries. Once Yamhill County sets the urban growth boundary, then it gets acknowledged and then it's settled, right? But then you try to mess with it again and you got to go back and get it blessed by the state, right? That was sort of the system. It was sort of peaceful in the land, right? Everybody was getting along. And then came farmland protection, right? Rules governing what uses can and can't happen on farmland, right? So much for the balance, right? And I feel like we're sort of in that again with housing, right? We've got a whole new slate of regulations about housing. I'm going to talk a little bit about that, and it's sort of changing the balance of what local governments can do and what the state can do, and that rejiggering is causing some tension. And so I think we're sort of in that same kind of place we were in the early 90s when LCDC promulgated a bunch of rules about farmland. We're sort of in that again, I think, now with housing. I'll talk a little bit about that. Questions about the statewide system? Okay. Land use planning in McMinnville. So when McMinnville reviews an application for development, it can fall into two different types of decision-making. There's legislative decision-making, and there's quasi-judicial decision-making. And legislative decision-making is long-range planning. It is policy-making. You are sitting as a little legislature deciding what the law should be. What should this zone be? What should we develop this part of our city to look like? What should these historic protections be for this area? What distinguishes legislative decision-making is it's more far-reaching. It is broad in its application. Sometimes it's hard to tell legislative decision-making from quasi-judicial decision-making, because sometimes if I file an application for a zone change, you're kind of making policy. Is it a good idea for me to change from industrial to commercial? That's kind of like policy making. But because it's only one property owner and it comes with concrete facts, Luba would say that is a quasi-judicial decision because it affects one person. I have come to the city asking for this. It is not that the planning department said, you know, we really ought to rezone those 4 properties over there. I have come to the city with a request. And because I come with one property, it's processed as quasi-judicial, even though it has some policy-making elements. The reason why we treat legislative decision-making different than quasi-judicial decision-making is because with quasi-judicial decision-making, it is a request for permission to do something with land. And that comes with an obligation for due process. And so because we have to give people who want to do something with their land due process and fairness and unbiased decision-making and a opportunity to have an understanding of what is in the record and what is out of the record, a limited record in that way, we have to give special process to quasi-judicial decision-making. Legislative decision-making, on the other hand, it's a political decision, right? It's freewheeling and dealing and talking about it over lunch and, you know, listening to the union and listening to the property owners and listening to all the people and hearing what they want the outcome to be. You're not committed to making a decision. You're not necessarily moving forward. It is not the same kind of proceeding as a judicial proceeding. Quasi-judicial is you sitting as a judge. That's why it's called judicial. So you take off the hat as a politician and you become a judge. So it is knowing the difference between those two things will set up everything that follows for these kinds of, for land use reviews. Time limits are different. Ex parte contact obligations are different. So the first question that I always ask whenever I'm asked a question, okay, are we doing this as a quasi-judicial or as a legislative? And when it might be close, which do you think we pick? Quasi-judicial, because it gives the most protection, right? My job is to ensure a process. My job is not to tell you what the outcome is. My job is to ensure a process, and if I think it's in doubt, I'm going to give more process than less. And so we try When we don't know, or we think it might be close, we go with quasi-judicial. So let's see, I think I covered everything on this slide. So Planning Commission and your Landmarks Committee, they are the final decision maker in most quasi-judicial proceedings, right? You only see those most of the, we call type 3 or quasi-judicial reviews if they get appealed, right? So if it doesn't get appealed, it doesn't come to you. But for legislative decisions, you are the final decision maker in all cases because you set the policy, right? Planning Commission comes up with a new concept plan for an area, they have to bring it to you to implement the code to make it so. Questions about that?
No questions from the little legislature. Thank you.
Okay. So let's break down the review categories a little bit in a little bit more detail. So there are administrative decisions. These are building permits first and foremost, but also home occupation permits, commercial design review, and when it's a standard design review, minor downtown design review. These are administrative decisions where there is no discretion. This is where an application comes in and it is a check the box determination of whether or not the building is, let's say, 35 feet tall, has 5-foot setbacks, has windows that show 30% transparency. These require review of quantitative standards. And so there doesn't need to be process because there's no question about whether something's less than 35 feet tall, right? There's no interpretation necessary. The second type of decisions are called limited discretionary decisions in McMinnville, and these are administrative variances, downtown design review, major subdivision, short-term rentals. These types of decisions are director's decisions with a limited notice. So the notice goes out to people, I don't know how far, I think it's 250 feet, but I could be wrong on that number. And there's a limited notice area, and then the notice says you have 14 days to comment on this application. And those comments get received by Heather, and Heather reviews the comments and makes a decision. And that decision goes out to all the people who submitted comments, and then those commenters have an opportunity to appeal that Heather's decision to the Planning Commission and then on to the City Council should they choose to do so. And limited land use decisions are provided in state law to be a category that includes design review and subdivisions. So that's why those things are allowed to have less rigorous review because they fall into that category. The third category is quasi-judicial decisions, and this is where the action is. This is where the drama is. This is where you all come in front and center as the appellate review body of decisions by the Planning Commission and the Historic Landmarks Committee. And this is these are the decisions that require interpretive, discretionary decision-making, right? This is where the criteria requires some exercise of policy judgment, and because of that, you have delegated those decisions to the Planning Commission and the HLC, and then provided review. Any questions about those categories? Okay, we're moving right along. I still see people awake, which, it's a good sign.
I mean, we do this for fun.
Seriously.
I think it's fun. I know you all don't. I just, I appreciate you for staying awake because,
We enjoy it.
all right. So review procedures. The reason why in quasi-judicial decisions there are really strict review procedures is because we want predictability and a level playing field, right? We want to ensure fairness in the system. And so both state law and your local code are very specific about the type of procedures that are applicable to quasi-judicial land use applications. And the first thing that the code says you have to do is have a pre-application meeting with staff, and usually a applicant has a conceptual proposal, and then staff puts together notes of their review of the application, and they give those to the applicant and said, okay, here it says, here are the code criteria that apply. Here are the areas where you might want to take some extra care. Here are the studies you're going to have to do in order to submit a complete application. So that happens, and then there's a neighborhood meeting where a developer goes and meets with the neighborhood to talk about the proposal, and then an application gets filed, and the application goes through what's called completeness review. And completeness review is where city staff checks the box to see that things that are required in order to process the application are filed. It's really important to distinguish completeness review from whether it complies with the criteria. The staff is not determining whether or not it complies with the criteria. They are determining whether the submittal requirements are present, right? There is a traffic study, whether it's, you know, one sentence or 40 pages, there is a traffic study. There is a wetland study. There is a DSL sign-off. What those say is not germane to completeness review. So state law says that local governments have 30 days to conduct the completeness review and notify an applicant of what is missing from their application. And so Heather and her team write a letter to an applicant and say, okay, you are missing these items. You don't have a narrative of how you comply with the criteria, or you don't have a site plan that is to scale, and so we put together a list of what's missing and we send it back to the applicant. And then the applicant has time to do one of three things. The applicant then can provide the additional material. Here, Heather, is the additional material that you requested. And please review it for completeness. And then Heather has time to review it for completeness, and she can come back with another letter that says still not complete, or she deems it complete. The second option for the applicant is, here is the missing information that you wanted, deem the application complete. Meaning, I don't care, Heather, whether you think this second batch is good enough, deem it complete. Third option for the applicant is, I'm not providing you anything, Heather, deem it complete, right? And the importance of completeness is because that's what starts the 120-day clock for making a decision. So that when the applicant comes and says, I am not providing you anything, deem it complete, that day that person says, deem it complete, is when the clock starts for the city to make a decision. So it's really important that we as staff are very deliberate about making sure that we get in writing the applicant's request to deem it complete, because we don't want waffling 60 days later about whether or not you said it was complete or you meant that it was complete. I mean, there's litigation, all over the place about what people have said or thought they said. And at the end of the day, LUBA looks at what's in writing. What the magic language is, deem it complete. Not, I want you to start processing it, right? Deem it complete, starts the clock, and then city has 120 days, and that's it. Yeah.
And so why would they want to deem it complete if it wasn't complete?
Because they don't agree. Either they don't agree with the staff's evaluation, or they intend to supplement the record as it goes along. Time is more important to them.
That I can understand. I just,
So there's lots of strategy that might go into it.
Interesting. Okay, thank you.
We've got a completeness determination. So then the next step is mailed and posted notice of the hearing, and state law and your local code specifies what the notice has to include. It has to identify the proposal. It has to identify the applicable criteria. It has to state that the staff report will be available 7 days in advance and how to get the staff report, who to contact at the city to obtain a copy of the staff report, and it has the information on when and where the hearing will be held. So then we have a hearing, and you all are, I'm sure, very aware of the legal disclosures that have to be made at the beginning of every quasi-judicial proceeding. Those are, that is not a script that's published by state law, but it is points that have to be covered through state law. Like the state law says that we have to tell applicants that they have to raise all their issues or they waive them. State law also requires that we say that if applicants have a constitutional objection to a particular condition of approval, that they have to raise the constitutional challenge at the hearing. They can't lay in the weeds and then surprise the city with their objections later. So all of those disclosures are required, and it's so that everybody knows the rules that the city is going to follow as it considers this, because it is a quasi-judicial proceeding, and so we have to be consistent with the formalities provided in the state law and the local code. You all know probably that at the initial hearing, any party has a right under state law to a continuance or rebuttal. And so at the initial hearing before the Planning Commission or before the Landmark Committee, there is this right to continuance or right to rebuttal. After the initial hearing, there is no right to a continuance or right to rebuttal unless new information, new evidence is submitted that others have not had an opportunity to respond to. So if I come up to the dais representing a opponent to a project, you've already heard from the applicant, I come up to the dais representing an opponent and I submit to you a new 100-page traffic study. And I explain to you during my presentation time all the reason why my traffic study shows that the applicant's traffic study is incomplete or unreliable. If you intend to take my traffic study as part of your decision-making, you have to allow the applicant an opportunity to respond to that evidence. Sometimes it can be hard to tell, who's had time, My sort of rule with that is there are often cases where, as an attorney representing private parties, I will have things to submit, and I will submit them the morning of the hearing. So I submit them the morning of the hearing. So Heather has my materials the morning of the hearing. So the applicant needs to call Heather and say, Heather, have you got anything for the hearing tonight? When I represent a party, I'm always emailing, Heather, have you got anything for the hearing tonight about 2 o'clock, so that I have a time to prepare. It can often be difficult for you all as decision makers to give applicants more time if you're up against the 120-day clock, right? Which McMinnville often is, because you have appeals that go to the Planning Commission and the Landmarks Committee before they come to you, which makes for a lot of decisions that have to happen in 120 days. So that can be a difficult choice sometimes, but that is the rule. The rule is there is no automatic continuance or an automatic right to rebuttal just generally, only when new evidence comes in that a person has not had an opportunity to respond to. At that point, then the record closes and we have deliberation and a decision, and then we have a right to appeal to the city council. Only those who have participated below have standing to appeal a decision, but Heather's not on, is she?
Yeah.
Oh, she is? Heather?
Yes.
Can I, do folks who have, if a person appeals has standing because they participated below, once the council takes a review, can anybody participate in the appeal before the council, or do all the people have to have standing in order to participate?
No, our code has it as a de novo new public hearing process.
Okay, so it's all brand new, anybody can participate.
Yes.
But a person has to have standing to appeal the decision in the first place.
Yes.
And then once they do that, they essentially open the door for everybody.
Yes.
Thank you.
Yeah.
Sorry to interrupt. So the important part for you, as Heather said, was it's a de novo decision with no required deference. So you're looking at it new. And you can decide whether to give deference to a lower body decision, but you don't have to. The alternative to that, if you were interested, would be an on-the-record hearing, which would review the lower body decision for errors. So you wouldn't take evidence, you would just review the record as it was put together by the Planning Commission or the Landmark Committee. And the reason why some jurisdictions think that makes sense is because why do you need to keep having more evidence come in? Right? It gets unwieldy because especially you've got three bodies making a decision. It's de novo the whole way. It's a lot of material and a lot for you all to digest. Land Use Board of Appeals, for example, is a closed record. If you go on beyond a city decision and you appeal it to the Land Use Board of Appeals, it's a closed record. So you don't have an opportunity to present new evidence. So the point is it could be done differently, but this is the way McMinnville does it, and it works out. Sometimes more smoothly than others, maybe, but it works out. Oh, the final note I wanted to say here is about the fixed goalpost rule. The fixed goalpost rule says that an application will be reviewed against the criteria that have been adopted at the time the application is deemed complete. So an application that is moving forward through the notice and review process, you change the law, that change in the law will not apply to that applicant. Questions about that?
It came up a lot when we picked the UGB back up, the UGB amendment back up because of the, because it was over 20 years old at that point. Councilor Peralta?
Yeah, this is, your comment seemed to me it was in the context of sort of new development, but how does this relate to what we were dealing with where people had a bundle of rights associated with their land, and then we go through that process, and then it seemed like they were not bound by those changes, even in the context of
And that was where you had an application, right?
Right, yeah.
I think the fixed goalpost attaches when you have an application for something, and I don't know, I know enough about your UGB expansion wars to be dangerous, but my understanding is that those were started by an applicant, went to LUBA, got remanded, it went up, got remanded, so it's been a ping pong, but the application is still the application. And so that fixes the goalpost for as long as that application is alive.
And I see our community development director is,
Okay, go ahead. I must have wrong.
So just to clarify, our UGB process was actually a periodic review task.
Oh,
And so when we picked up the court appeal, we made a decision as a city to respond to the remand that came through the Court of Appeals down to us from LCDC. So we had a very narrow needle to thread on that one, but that was a legislative process. We have had a couple of quasi-judicial decisions where we have as a city, made decisions on property. And like over by Baker Creek and Hill Road's a great example. And then either the property sell and the applicant comes in and wants to amend the decision that's been made. And so we do a lot of plan development amendments that way. When they come in for the application to amend the plan development, that application is reviewed under whatever the existing code is at the time they submit that amendment application, and not the previous application's review. And so we've seen that as the city a couple of times as we've gone through some of these larger projects. But the goalpost remains the same. When they submit it to the city at the time of submittal and deeming it complete, that is the rules in which we're working in terms of the adopted rules. Now that just changed in the legislative session. We will now have new housing rules where a developer can choose to participate under new rules if a city adopts new rules while their application is in process. And we'll work through what that means in terms of process here over the next year.
thank you.
thank you, Heather, for the clarification. Okay, do you want to move forward to the 120-day rule requirement? I think I covered most of the things in this slide. The applicant controls the completeness deadline, so it's only the applicant that can extend that 120-day timeline. An opponent can't come and say, I need more time, delay the decision after the 120th day. Only the applicant can decide whether to extend or not. The entire application, including appeals, has to be resolved within 120 days. And then failure to make a decision within 120 days gives rise to a right to mandamus in circuit court that may include attorney fee recovery. And I think the last time I may have talked to you all was in a mandamus situation for a short-term rental last year.
And I think, Carrie, if I could just add, oftentimes the decision-making body, be it the Planning Commission, Historic Landmarks Committee, or the City Council, you will see staff sort of negotiating with the applicant on the 120-day rule if we know the clock is soon. And so then you'll often see, do you want to we call it toll the clock. Do you want to total clock, give us more time so that this decision-making body can work through the process and get you a decision that they're comfortable with. And the applicant will then strategically decide whether they can get a yes or no from you based on that time frame. So if they force it and don't toll the clock, will they get the yes that they want? Or if they provide more time, will they get the yes that they want? But you'll see those negotiations happening in real time during your process right there between the applicant and staff as we try to negotiate through that.
Thank you.
Moving on to a more pleasant topic. Public hearing roles and responsibilities. I think it's, this slide, the material in this slide came from a local government CLE that I participated in a number of years ago, and I really like it because I think it shows that everybody kind of has a job to play, a role to play, and everybody needs to sort of play their role for the system to work the way it's envisioned. And if one of these jobs isn't fulfilled, then the process doesn't really run very smoothly and efficiently, and it makes it really difficult for others to sort of decide where they're picking up the other's job. So The applicant's job, as you know, the applicant bears the burden of proof. So the applicant has a job to understand the approval criteria and submit evidence that shows you that those criteria are satisfied. They bear the burden throughout the whole process. It is not the opponent's job to show you that the criteria are not satisfied. It's the applicant's job to prove that with evidence that the applicable criteria are satisfied or will be satisfied with conditions of approval. And that can be sometimes hard to keep straight when you have applicants and opponents disagreeing, but that's their job. The planning and legal staff, as I mentioned, my job and planning staff's job is to administer a process. We are to guarantee a particular process that complies with state law. We're obligated to provide the notices, provide the staff report, and to be there to assist you in making a decision. And so providing assistance on what the law says, but there's a lot of sometimes a lot of distance between what the law says on one side and what the law says on the other. And so that's where you come in. That's your job. My job is just to tell you where the do not go outside boundaries are. You are to interpret the standards consistent with your criteria. Our job is to, as staff, is to provide technical advice. I'm sure that the city has on contract traffic engineers and public works engineers who provide advice to the council about technical things. We, of course, are obligated to know what the comprehensive plan and land use regulations are and to assist not just the council, but also the public about what those requirements are. Neighborhood groups, others are, their job is to review notices and when the time is right to participate and come and tell the council and the planning commission and HLC what they think of things. And the system doesn't work too well with an empty room. And so their job is to raise concerns. Their job is to participate in the long-range planning opportunities and to share their insight on how criteria should be interpreted or how they should be drafted when you're in a legislative decision. And then you as the decision maker are charged with reflecting the community values when making planning policies, interpreting and applying plans and regulations, to educate the public and provide a public forum for folks to air their grievances, raise their concerns, do your homework. I think that's one of the most difficult tasks when the records get long for you all. I think it's really difficult for decision makers, especially when you're at the back end and the time is tight and the record is lengthy. What I advise my folks that I work with is rely on staff. Email Heather and say, Heather, I have time to read 20 pages. What are those 20 pages? I have, Heather, I gotta find the summary of this because it's so lengthy. Tell me what, I have some counselors who come and meet with, independently, on their own, meet with city staff before a hearing to talk about, sort of make sure they understand complicated applications. There is no prohibition to you having conversations one-on-one with city staff. There is no limitation to that. So please use us as a resource to help you form your questions or be prepared or make sure you understand. That's really something that is there's nothing I think more difficult than coming to a record and seeing, the PDF has 400 pages and you're like, I didn't plan to spend my beautiful Sunday afternoon pouring through 400 pages. So do what you can, but again, work with staff because that they can be, we're in the trenches, right? We're writing the staff reports. We know what the application says, so use us as a resource. Treat staff and other elected officials with professionalism and respect, and then be courageous and don't be afraid to ask hard questions, to ask uncomfortable questions, to call out counsel, please.
I do have a question. We've had decisions that had like 1,200 pages. I mean, they're really lengthy. And sometimes I feel like staff throws everything but the kitchen sink into it. So it's interesting for me to hear you say, you know, give me 20 pages and I can read in time. I just sometimes wonder if there's, you know, like a whole pamphlet and only the one chapter is pertinent to the particular situation. Couldn't they just pull the chapter out and give that instead of the whole?
So the reason why the staff reports are so lengthy is because we have to do adequate findings, which means we have to explain where the, how the evidence shows that the criteria are satisfied. So I appreciate that, you know, it's daunting. And again, I'm trying to be practical, right? So I would email city staff who's on this and say, where's the controversy here? You know, this is being, what does the appellant care about? Because there's a lot of findings about sidewalk depth and curb width and flashing type that may not be germane to the issues that the appellant cares about. So there's no need to review in detail how, you know, how the roads are going to be built if everyone's in agreement that the standards are satisfied with respect to the roads.
I think that's a interesting perspective, since it's falling under the bullet point of do your homework. I guess it would be easier to be in Ms. Richter's class than Mayor Drabkin's class because I would expect you to read the whole packet every time. And I guess it gives me a little pause to encourage an elected body not to go through it as thoroughly as I think this council holds itself to a very high standard in terms of reviewing information. So I'm a little. I have a little pause with that recommendation. I not on the part of leaning on staff and asking lots of questions, but I would hesitate to encourage this body to approach any of the packets that come before us as if they don't need to be read cover to cover. I think that's important and important for your own learning as well, and will actually aid you in the process, because it'll help you catch inconsistencies if you are thoroughly reading through each packet. That's my opinion. I see Community Development Director Richards has her hand up.
Yeah, I'd like to hear what she says.
Yeah, so
Louder, please.
I would say we set up, I beg your pardon?
Oh, we're just turning up the volume on your mic a little bit so we can hear you better.
Okay, and my internet is unstable, so I apologize. Our staff report is deliberately set up in 3 parts. Well, more than 3 parts, 5 parts, but 3 parts relative to the information. So you have a report and brief. That's telling you what your decision is that's in front of you that evening. We have a background section that's telling you the history of this application as it made its way to you. And then there's a discussion section. And the discussion section is where we discuss things much like Carrie just described. These are the conversations that came up at the Planning Commission level that were of concern. These are the studies that were provided that provided additional information, blah, 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 blah. We try to put in that discussion section the things that we think that we're calling out for you, that we think you really need to know about. And then when the packet, we need to provide you the whole record. When the record is lengthy, we are also trying to provide it in binders that have different divisions in them so that you can use it as a resource. So if in the discussion, we say, you know, the traffic was a big discussion at the Planning Commission level, and here were some of what it revolved around. We then try to identify where in that record you can find the traffic study. So we're trying to point you in different directions so you can find the information that's important to you, and also what was the, different arguments that we heard as this project was making its way through the public process. So I encourage you, the staff report is set up to help you navigate that large packet that you're receiving from us.
Thank you.
So just to close the loop here, I don't think I'm saying don't read the materials. I think what I'm saying is use your judgment about what is the important things and focus on those things, because that is where the interpretation is in doubt. And that is where there is room for discretion, I think. And I think you as a decision maker are prioritizing where you're going to focus your attention. And there are some records that it's like the dictionary. You could read all 800 pages, but you can't absorb 800 pages. And so you're going to have to prioritize. So I didn't mean to imply that you should, anyway, my apologies, Mayor Drabkin. I didn't, I read everything and
Perfect, go on. Okay, read up.
I know we're out of time here, so I got to go faster. Impartial tribunal. I'm going to cover this quickly because I think you probably know. Ex parte contacts in quasi-judicial decisions have to be disclosed. Ex parte contacts are any communication you have with any party on the substance of an application outside of the public hearing, recorded hearing process. Okay? So that includes newspaper articles, social media, conversations. You hear somebody at the table next to you at the coffee shop talking about it. Those are ex parte contacts, and you have to disclose the substance of those contacts so that they are in the record so that people can comment on them. If you disclose your ex parte contacts, that cleans the record, it cleans your, cleanses your spirit, and you are free to participate because you have put into the record the things that that you got as evidence. So then an applicant can respond, an opponent can respond. So that's why we do it. It is far easier for you to track ex parte contacts as you get them than to make it up after the fact. So you run into somebody at the grocery store and they say that, that proposal's terrible. You say, I appreciate your comments. We're having a hearing on it on Tuesday. Come to the hearing and make those that position known. You get home, you send Heather an email and say, Heather, I ran into so-and-so. This is an ex parte contact, and then it's documented, right? And then you come to the hearing. Heather has a list. You have an email sent chain of all the times that you had an ex parte contact that then you can refer to, and you don't have to remember. If you read a newspaper article or you read a blog, send a copy of the article or the blog post or whatever social media thing you read to Heather, and we'll just put it in the record. Once it's in the record, not a problem. Decision makers have to be free of actual bias. Actual bias exists when there was a decision that was the result of a positive or negative feeling about the proposal that is not related to the criteria. I was going to talk about the Rosenwig case, but I won't have time. So are you the counselor who was at issue in that case? I have to know.
What are you talking about?
There's a Luba case from 2011 where, in McMinnville, where an applicant was proposing a subdivision, a zone change, and the counselor, who I think's name was Minky, the counselor was on the board of Habitat for Humanity, and the zone change was for Habitat for Humanity housing on Atlantic Street.
It was the Aspire development.
Or it might have been.
It was Marcy Rosenzweig. Remember, she led the opposition on the
It might have been.
development.
Anyway, so it was it stands for proposition. You were, Counselor Menke was challenged for bias because she served on the board of Habitat for Humanity. And the question was, did she review all of the evidence or did she make a decision because she liked Habitat for Humanity? And what Luba said was that the challenger did not show that the decision was made not based on the evidence, but was made on a personal preference for Habitat for Humanity. So the lesson of that case is if you're going to shoot at the king, you got to kill him, right? If you're going to allege bias, you got to have evidence to show that they're biased. And Luba has a very high bar for bias because they understand that you all are decision makers. You're out in the community. You run into people, you're involved. We want you to be involved in boards and activities, and that's part of why you were elected. The idea here is that bias is something where you cannot set aside your personal preferences to put on your judge hat and make a decision based on the criteria. So oftentimes when I'm advising a counselor on a bias challenge, the question that I ask to the counselor is, can you make a decision based on the criteria? Not setting aside your personal feelings and make a decision based on the criteria. If the answer to the question is yes, you can participate. If the answer to that question is I'm not sure, then you probably shouldn't participate. Third issue related to a partial tribunal has to do with conflicts of interest. Conflicts of interest have to do with you participating in a decision where you or a member of your family stands to gain or lose on a pecuniary basis. And those sorts of conflicts of interest, you can't have any actual conflict of interest, and oftentimes where there's a question about that, I encourage my counselors to call the Oregon Government Ethics Commission because there's a whole body of laws about sort of how to sort that out. So they can be a really good resource. Okay, I have 3 minutes and
So, but this is great, and I want to tell you that I had a counselor come to me the other day, or I was speaking with a counselor the other day, I should say, who also did your training with historic landmarks and loved it and was so complimentary and said that it was one of the best land use trainings that they'd had in their time serving on council. I also think that this is great. I don't know what all of the schedules look like going forward, but I think it would certainly be wonderful to have you come back and do the second half of the training in another work session as opposed to trying to slam through half of it in the last 2 minutes, which it doesn't seem reasonable to me. So if you feel you're at a good stopping place, I think it's a good place to pause.
I am sorry I didn't get further.
Don't be. This was great.
No,
Thank
we
you so
appreciate you
much.
answering
Yeah.
Can
Yeah.
we get the other 4 hours?
No, thank you so much for coming today. It's really nice to have you here in person. We appreciate your time. We appreciate you sharing your expertise with the community and with the council, and helping us make sure that we know we've got our dotting our I's and crossing our T's and understand the rules by which we govern. So thank you again so much for your time. Community Development Director, did you want to say any final words to close us out on the work session?
Just wanted to say, if you are interested in having Carrie back to finish up the training, I do think the remaining training is important. We'll look for a time to do so. Carrie, thank you so much for coming in and providing this to all of our decision-making bodies. It's been very helpful.
Yes, wonderful. Thank you for your time, and we will look for a follow-up work session date. Thank you.
Thank you.
With that, I am going to close the work session at 6:59 p.m. And we will take a 1-minute break to clear your things and let everybody grab their seats, and we'll come back at 7 o'clock for the regular meeting.
I enjoy. Nice to meet you too.
Okay.
All right, I'll invite staff and council back to find their seats, please. I'm well, thank you. All right, I will just invite council to return to the dais here so we can get started, please. Wonderful, thank you. Good evening. Welcome to the May 14th, 2024 regular business meeting of the McMinnville City Council. I would like to call the meeting to order and request Daniel Ruiz to do a roll call.
Councillor Menke,
Present.
Councillor Chenoweth,
Present.
Councillor Payne,
Here.
Councillor Peralta,
Here.
Councillor Geary is absent today, Council President Garvin,
Here.
and Mayor Drapkin.
Here, thank you. And I've asked Councillor Payne to lead us in the Pledge of Allegiance. Please rise. Of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, Councillor Payne. Thank you, everyone, for being here this evening. Tonight we have some proclamations. We'll take comments from community members, advice and information. We have a short consent agenda, and then a resolution related to the fire district transition. And thank you to the fire brigade that's in the room this evening. We appreciate your service all of the time, and thank you for being here. We'll get to your item as quickly as possible. We're starting tonight with a proclamation for National Emergency Medical Services Week, so poignant as well. And whereas emergency medical services are a vital public service, and whereas the members of emergency medical services teams are ready to provide life-saving care to those in need 24 hours a day, 7 days a week, and whereas access to quality emergency care dramatically improves the survival and recovery rate of those who experience sudden illness or injury, and whereas emergency medical services have grown to fill a gap by providing important out-of-hospital care, including preventative medicine, follow-up care, and emergency medical transport. And whereas the emergency medical services team consists of first responders, emergency medical technicians, paramedics, emergency medical dispatchers, firefighters, police officers, and other out-of-hospital medical care providers. And whereas the members of emergency medical services teams, whether career or volunteer, engage in thousands of hours of specialized training and continuing education to enhance their life-saving skills. And whereas emergency medical team members have stepped up during the time of the COVID-19 pandemic through stressors such as policy change, increased PPE wear, and potential exposures, and whereas it is appropriate to recognize the value and the accomplishments of emergency medical services providers by designated Emergency Medical Services Week. Now, therefore, I, Remy Drabkin, Mayor of the City of McMinnville, do hereby proclaim the week of May 19th to 25th, 2024 as National Emergency Medical Services Week in the City of McMinnville, and I urge all community members to observe Emergency Medical Services Week and support our first response resources throughout the city. In witness whereof, I have hereunto set my hand and caused the official seal of the City of McMinnville to be affixed this 14th day of May 2024. And thank you for being here. Would you like to, do we have two copies of, would you like a copy of this proclamation, Chief? Okay. Thank you. We're also proclaiming this National Public Works Week. Whereas public works professionals focus on infrastructure, facilities, and services that are of vital importance to sustainable and resilient communities and to the public health, high quality of life, and well-being of the people of the City of McMinnville. And whereas these infrastructure, facilities, and services could not be provided without the dedicated efforts of public works professionals who are responsible for building, maintaining, improving, and protecting our community's transportation, water, and power supply, water and wastewater treatment systems, public buildings, parks, and open spaces, and other structures and facilities essential for our community members. And whereas it is in the public interest for the community and civic leaders in the City of McMinnville to gain knowledge and to maintain a progressive interest in understanding the importance of public works and public works programs in our community. And whereas the year 2024 marks the 64th Annual National Public Works Week, sponsored by the American Public Works Association, now therefore I, Remy Drabkin, Mayor of the City of McMinnville, do hereby designate the week of May 19th to 25th, 2024 as National Public Works Week in the City of McMinnville, and I call upon all community members, business leaders, and civic organizations to recognize the substantial contributions that the employees of McMinnville Water and Light and the employees of the city's Public Works Department, which includes engineering, operations, wastewater, and the airport, make to protecting and enhancing our health, safety, and quality of life. In witness whereof, I have hereunto set my hand and caused the official seal of the City of McMinnville to be affixed on this 14th day of May, 2024. And I would be remiss not to note that we will have the community fair on May 30th, which will also be honoring many of our public works workers, as well as our fire teams and police. So we hope you can join us in. And Public Works Director, Mr. Hunsaker, would you like a copy of this proclamation? And we would also like to proclaim this National Police Week, which it is. Whereas the Congress and President of the United States have designated May 15th as Peace Officers Memorial Day, and the week in which May 15th falls as National Police Week. And whereas the members of the Law Enforcement Agency of McMinnville play an essential role in safeguarding the rights and freedoms of McMinnville, and whereas it is important that all community members know and understand the duties, responsibilities, hazards, and sacrifices of their law enforcement agency, and that members of our law enforcement agency recognize their duty to serve the people by safeguarding life and property, by protecting them against violence and disorder, and by protecting the innocent against deception and the weak against oppression. Whereas the men and women of the law enforcement agency of McMinnville unceasingly provide a vital public service, now therefore I, Remy Drabkin, Mayor of the City of McMinnville, do hereby proclaim May 12th to 18th, 2024 to be National Police Week, and call upon all McMinnville community members and upon all patriotic, civic, and educational organizations to observe the week of May 12th to 18th, 2024 as Police Week, with appropriate ceremonies and observances in which all of our people may join in commemorating law enforcement officers, past and present, who by their faithful and loyal devotion to their responsibilities have rendered a dedicated service to their communities, and in doing so have established for themselves an enviable and enduring reputation for preserving the rights and security of all community members. I further call upon all McMinnville community members to observe May 15th, 2024 as Peace Officers Memorial Day in honor of those law enforcement officers who through their courageous deeds have made the ultimate sacrifice in service to their community or have become disabled in the performance of duty. And let us recognize and pay respect to the survivors of our fallen heroes. In witness whereof I have hereunto set my hand and caused the official seal of the City of McMinnville to be affixed on this 14th day of May, 2024. Chief? The chief and I have a lot of pictures together. Now go to the section of the evening where we take comments from community members. Any interested audience member is invited to provide comment, and any comment provided that requires some type of follow-up will be assigned to a staff member. Anyone may speak on any topic other than a matter in litigation, a quasi-judicial land use matter, or a matter scheduled for public hearing today or at some future date. Comments will be limited to 3 minutes per person for a total of 30 minutes. If you wish to speak and you're on Zoom, please use the raise your hand feature and request to speak. When your turn is up, we'll announce your name and unmute your mic, or you may send a chat directly to our city recorder and we'll announce you. When you testify, please announce your name and the city you live in for the record, and please remember to fill out a public comment card to submit to the city recorder prior to leaving for the record. Claudia, do we have anyone signed up? Or Daniel, do we have anyone signed up? Daniel, do we have any signed up for public comment this evening?
We do not have anyone signed up.
Is there anybody in the gallery or on Zoom that would like to provide public comment this evening? No? All right, thank you for being here. We'll now go to advice and information from counselors on committee boards and assignments. I'll start to my right this evening with Counselor Menke.
I only have one comment. YCAP, I think, is going to finally get their audit closed, past due, but they're excited. It's been a long time coming.
Thank you. Counselor Payne?
Thank you. Landscape review has canceled the last two meetings, so I'll just move right into the local public safety coordinating council. On the 2nd and 3rd, I had the honor and pleasure of meeting with community partners as well as consultants to participate in the strategic planning session for the creation or hopeful creation of a family justice center to serve Yamhill County, which would effectively put all of our justice nonprofits and services under one roof. So we dreamed really big, and we talked a lot about barriers and concerns and connections and opportunities to continue dreaming this dream.
Right. Thank you so much. Counselor Peralta.
Thank you, Mayor. Council of Governments Legislative Committee meets tomorrow. MCM 11 Committee meets next week, as does League of Oregon Cities, so no report. Thank you.
Thank you. Counselor Chenoweth.
Yes. Can you hear me okay?
Yes, sir.
So MEVLC met, and basically we went over the session accomplishments of our good House Rep Lucetta Elmer, discussed the wonderful housing bill that was passed, which is quite an accomplishment for a freshman in a minority party to get a almost unanimous bill across the finish line. And had a relatively short session because that was the entirety of it. Thank you.
Thank you, Council President.
Thank you, Mayor. YCOM would have met today, but our budget committee meeting got moved 2 weeks out for some scheduling conflicts. Airport Commission should have met last week, but we're actually meeting next Tuesday, and you'll see something in your 28th packet, a contract in there. So keep your eyes peeled for that. Visit McMinnville meets tomorrow. We do have our CEO, Jeff Knapp, taking off to take a position in Visit Bend in about a month. So we'll have a opening there and be doing a recruitment, and wish him well. It's quite an opportunity. You know, Visit Bend is, I believe, the biggest DMO in the state. So advancement for his career, as well as a good fit for some family stuff over there. And I think our recruitment should be pretty strong given the quality of organization Visit McMinnville is, and the trajectory they have and the projects they have on the table. I think it shouldn't be too hard to get a good applicant pool. But I'll keep you guys posted on that. Fire District, I'm excited to do a State of the District with Mayor Drabkin at the City Fair on the 30th. So if you want to be brought up to speed on everything Fire District, be sure to attend that. Thank you.
Thank you very much. You may all have read or not read the book that I gave you at the end of the year, but it did spark some community conversation, including with the First Presbyterian Church. And so I've met a few times with Pastor Johnson, and he felt it was a little bit of a lift to ask their whole congregation to read that book as well, but he came back with a great idea, which was to partner with an organization called Braver Angels. And so there are 2 upcoming events that First Presbyterian will be hosting. The first, I believe, is on May 21st, and it's called Dinner and a Fight. And essentially, they bring in 2 people to model how to have a conversation when those 2 people hold genuinely different views, where they've already agreed upon some basic rules for the conversation, and then they push that same difficult topic out to the tables, and each table has a monitor added, and that monitor helps people abide by the rules and have productive conversations about things on which they don't agree. And then there's a follow-up event that we are providing. I believe it's going to be at the library. We were able to partner and provide space for the follow-up event, which is on June 1st, and it is it's a workshop called Depolarizing Within. So just want to thank our community partners for bringing that important work forward. Additionally, as you all know, we're in the process of having one-on-ones with the council. So if you're not signed up for a time yet, we're just about ready to wrap those up. So if councilors could get with Claudia to schedule that time, that would be great. I also was able to meet with the new executive director of Homeward Bound. She was a former Willamette Law student that specialized in domestic violence and ended up doing lots of nonprofit work in animal advocacy before coming back to run the program here. And the outgoing executive director is staying on board to help them through their capital campaign of fundraising, and we expect to be pushing out a little bit more information about that through my newsletter. Additionally, I was able to meet with Zero Waste and some of their new goals, and as part of the overall kind of sustainability umbrella that's going on in regards to a number of nonprofits and businesses, the edible landscapes will be applying to do a rather large grant that would establish a commercial kitchen that would allow for some food processing from farm products. And then coming before you in not too long will be a resolution to support Chapul Farms working with the COG on a grant. And so we wanted to move that to the council as a whole to show council support as opposed to just a letter from my office. I also was able to meet with First Baptist this week, who is working on transition planning with YCAP for when the Navigation Center does open. And then additionally was able to meet, I'm actually meeting twice this week with Empower, and we had today's meeting already set, and then there's another meeting coming up at the end of this week because the Belgian consulate, and they're now a Belgian-owned company, their parent company is a Belgian company, and the Belgian consulate is coming to meet at Empower, so we look forward to hosting them there. And boy, so many more things I could share, but my time's up, so I will hand it over to our city manager, Jeff Towery.
Thank you, Mayor, members of the council. A couple of items to report tonight. We're a couple of months into our intergovernmental agreement with Yamhill County for our community outreach services, so I thought I'd give you a status report. Over the last 2 months, the COS team has provided 15 hours of proactive outreach, 57 plus hours of patrol on 3rd Street, a little over 9 hours of briefing time with the police department, as well as a 1 hour training session. So total of 82.5 hours, which averages about 9.2 hours a week. The IGA calls for 52 hours a month, so we're a little bit behind on that, but they will make that up. The IGA also calls for regular quarterly reports, which will begin in June and be provided to this body, also to McMinnville Industrial Promotions and our executive team. I know you all know this, but for the public record, I'll note that our budget committee convenes next Wednesday evening in this room as well as Thursday, and we're reserving Friday for a 3rd meeting as needed. And then just to follow up to the mayor's report on Braver Angels, I will commend that experience to you. I had the opportunity to participate in 4 Braver Angels sessions over the course of my travel last year for the International City County Management Association. A great opportunity for perspective and learning new skills to engage in challenging issues. That's all I have. Thank you.
Thank you so much. Special Projects Manager Jody Christensen.
Thank you, Mayor and Council. I'm here to support an agenda item on the consent agenda if you have questions, but I'd also like to share with you that the 3rd Street Improvement Project will have our community forum Monday, May 20th in this room from 5 to 7. The community will have an opportunity to get an update on the project and look at some of the design elements, and we want to make sure the community has an opportunity to weigh in on that. And then on May 31st from 1 to 5 in the large conference room in this space, we will be holding the Project Advisory Committee meeting. This is number 5. We'll be taking a look at the 15% design. We'll have a cost estimate based on that 15% design, and we'll have an update on the latest tree survey.
Thank you so much, Chief of Police Matt Scales.
Thank you, Mayor and members of the council. Just real quickly, as we roll into the new updated ordinance for prohibited camping, our training, roll call training in-house has been completed with Q&As with our staff. We've also provided flyers to our officers to provide to those that we are likely to encounter on the street. During that, noting the changes with specificity. I'm happy to report that our RV lot that we've had nearly jam-packed this last probably month and a half, we're able to locate somebody that has taken, I think, close to 11 RVs. So we've got space in there now that's going to allow us to work actively if we need to in the event. I'd also like to add, as I always talk about hiring, we have continued to push. We had 9 interviews today. I believe the majority of them actually showed up, but we also have had an interview with a lateral officer from, believe it or not, Tennessee. They want to move back to the McMinnville, Dallas area. and we provided them with a background. And then also we've got a couple laterals that are in the, we're just waiting for them to start. Lastly, just a reminder, I will be out of the office after this meeting tonight for an extended period of time, dealing with some medical stuff. I've sent notice, Captain Simons is the point of contact for the police for Mr. Towery, and then also council. And then Scott Fessler, Captain Fessler, will be doing the budget portion for the police department next Wednesday. So please allow some grace. I know he's a little stressed out, but he's going to do just fine. So that's all I have to report tonight. Thank you.
Thank you. I'll go on Zoom to Heather Richards.
Nothing to report tonight, thank you.
Thank you. Public Works Director Jeff Hunsaker.
Nothing tonight as well.
City Recorder Claudia Cisneros.
Nothing for the council. Thank you.
Deputy City Recorder Daniel Ruiz.
Nothing to report, thank you.
All right, thank you so much. We're now going to our consent agenda. Would any counselor request to have any item removed from the consent agenda and heard on its regular place? Not hearing any, I would ask for a motion to approve the consent agenda as presented.
I so move.
Second.
I have a motion from Counselor Mankey and a second from Counselor Peralta. All those in favor, please signify by saying aye.
Aye.
And those opposed say nay. And the agenda has been approved unanimously. And we'll now move into resolutions. And tonight we're going to consider resolution number 2024-21, adopting a fiscal year 2023-24 budget amendment for the Fire District Transition Fund. Our finance director is out ill this evening. I would like to call on City Manager Jeff Towery to present.
Thank you, Mayor, members of the council. We believe this is the last action we will bring before you with respect to the transition between the city and the McMinnville Fire District. When the budget was approved last year, we contemplated the transfer of a debt associated with purchasing a new fire truck to the district. That was what was in the intergovernmental agreement between the city and the district, and so we did not budget for the payment, the balloon payment that is due at the end of this fiscal year. The lender declined to reassign the debt to the district, and so the debt remains on the city's books and the city's obligation. The district is making the city whole, so there's no out-of-pocket budget implication for the city, but because the debt is still ours, it has to be, the retirement of the debt has to be budgeted. So this budget amendment is before you tonight to allow us to receive the revenue from the district and pay off the debt for that fire truck. And our recommendation is that you approve the resolution this evening. I'm happy to answer any questions you might have.
Thank you very much. Is there any council discussion or questions? I would ask for a motion to approve resolution number 2024-21 as presented.
So moved.
Second.
I have a motion from Council President Garvin and a second from Councilor Peralta. All those in favor, please signify by saying aye.
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 And those opposed, say nay. And the resolution has passed unanimously. And I'll now adjourn the council meeting at 7:27 p.m.